morning, and thank you for standing by. All participants will be able to listen only until the question and answer session of today's conference call. At that time, if you would like to ask a question, you may do so by pressing star, then 1. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I would now like to turn the call over to your host for today, Ms. Linda Abbruzzese. Ma'am, you may begin.
Thank you, and good morning for those of you joining on the East and West Coast. Thank you very much for joining us for our webinar on support documents. I am pleased to note that we have more than 40 people registered for this webinar today. My name is Linda Abbruzzese. I'm an International Trade Specialist for the Marketing Communications Office for the U.S. Commercial Service at the Department of Commerce. This webinar is being brought to you in cooperation by the U.S. Commercial Service and the Bureau of Industry and Security. I would like to welcome all participants in the export community who are joining us from all across the United States to learn how to obtain additional documentation in support of an export or re-export license application. You'll learn how to use these additional documents, making representations regarding the final disposition of the exported items. You'll also learn when support documentation is required and which document is the correct one for your transaction. In a moment, I'll turn this presentation over to Doug J. Bell, Export Administration Specialist of the Outreach and Educational Services Division of the Bureau of Industry and Security. He will be available at the end of this presentation to answer your questions. For those of you who just joined, you can still join to the internet to view this webinar by entering the URL website and passcode per instructions that were sent to you by email. Now, we do have a few housekeeping details to make sure everyone gets the most benefit from this morning's webinar. You are able to hear this presentation via your telephone, and you can view it simultaneously via your computer. If you're not hooked up through both, please take a moment to do this. And if you're experiencing any technical difficulties, please press star 0 anytime during this presentation. We will be taking written and voice questions. To ask a written question, we do invite you to type in the questions on your screen as they occur to you during this presentation. There is a Q&A icon on the top of your left-hand side of your screen where you can click and type in your questions anytime during this presentation. We will compile the questions and present them as many as time allows. Type questions which are not answered during this webinar will receive a personal answer via an email. Also, to ask a voice question, please press star 1 and the operator will assist you. In addition, for those of you who are in this webinar, we do have a copy of the PowerPoint presentation slides and attachments and handouts that are necessary in viewing this webinar, which can be found on the icon on the upper right-hand side of your computer. This icon looks like there are 3 pieces of paper overlapping one another. If you place your mouse's cursor over that icon, you can download the PowerPoint presentation slides as well as the handouts and attachments that will be very helpful for you when we go over the information in this webinar. Also, please note, for those of you who are involved in this series, that it's very important that you also attend the export compliance information that is going to be held pretty much towards the end of this session. The export compliance information and content is very vital and important for this series. So if you haven't registered for that portion as well, I would highly recommend that. And now, with no more information on the webinar part, I'd like to introduce live online Doug Bell, the Export Administration Specialist of the Outreach and Educational Services for the Bureau of Industry and Security, who will be our main speaker. Doug, thank you very much for joining us.
Thank you, Linda, and good morning, everyone. Again, I am Douglas J. Bell with the U.S. Department of Commerce, Bureau of Industry and Security, and today we're going to discuss support documentation that is required for export license transactions here at BIS. And because of a scheduling conflict, actually we're going to do the support documentation before we get into the actual license submission procedure. So that will follow after the support documentation briefing. So let's get into the topics of discussion for this morning. Who can apply for the export license, and what is the required support documentation for those transactions? Before you should see the decision tree. This is a pictorial of the steps in our case-by-case review that determines first and foremost at the top what is subject to our regulations, the Export Administration Regulations. If you're not subject, none of this information would apply. If you are subject, if you follow the arrow directly down the center, is your item classified under a particular ECCN on our Commerce Control List? If yes, you go to the left and follow that guidance. So we are actually at the bottom center, submit an application for the license. So we've gone through the steps, determined we are subject, identified our ECCN, identified the reasons for control, and now we know we need an export license, and we're going to find out what are the support documents that are required for that export license. But first, who may submit a commodity classification? If you have any questions about your ECCN, your Export Control Classification Number, anywhere in the world, you may submit the official request to the Commerce Department here in Washington, D.C., and our engineers will review your information and respond in writing with the official ECCN, again, the Export Control Classification Number for your item. So again, any person located anywhere in the world may submit the official request for the ECCN. Now, who can apply for an export license? If you are involved in an export transaction, international sale, or shipment originating from within the United States, you would have to be located physically in the U.S. Only a person physically in the U.S. can apply for a license to export. And that's simply because, again, from the U.S. government perspective, an export transaction is a shipment leaving from the U.S. So it's going to be a little difficult to orchestrate that transaction if you are outside the U.S. and you legally cannot do so. So again, only a person in the U.S. can apply for the export license. Now we have different types of export transactions. The standard export transaction and what's called a routed export transaction. So let's see what the difference is. And before we get into the distinction between those two, this is what will come up when you submit your export license application through the SNAP-R system. Again, that presentation will be following this presentation later today. But this will be the screen the exporter will see, and this is the information that the Commerce Department will need in order to process the application. So again, two types of export transactions. Standard export transaction. That's basically the type of transaction most of you in the export community are familiar with. A supplier, an entity here in the U.S. has made contact with a potential customer outside of the U.S. That supplier is making arrangements to ship directly to that customer. The responsibilities of that supplier here in the U.S., which we would refer to here at BIS as the U.S. Principal Party in Interest, or USPPI, their main responsibility is determine what authority they can consummate the transaction. Basically, as we noted through the pictorial graph, you first identify whether your item is subject, then you identify the ECCN. If it is subject to our regulations, based on that ECCN, you'll know what concerns the U.S. government has for this item to be sent to any customer in any location. With that information, effectively, you have determined whether your transaction requires an export license or not. So if it does require a license, then you must apply for that license prior to the shipment. Most often, your transaction will not require an export license. And when I say most often, Most often, I'm speaking of 95 to 98% of all export transactions subject to our regulations will not require an export license. So if you don't need a license, there's some other authorization that you would use to conduct your transaction. Usually that would be no license required, or NLR. And that is because after that review of the details, the ECCN and the reasons for control, your particular destination, and you're looking for an X on the country chart coinciding with where the reasons for control intersects with your country on the country chart. If you don't see an X under any of the reasons for control you saw under your ECCN, that would mean your transaction does not raise enough concern to the U.S. government that the export license is required. In that case, you would screen your customer to make sure they're not on any of the lists found under the list to check link, and as long as they're not there and we don't have any other concerns about your transaction, then you ship under the authorization no license required for NLR. But what if you do see an X on the country chart? That indicates there is enough concern by the U.S. government that a license is required for your transaction, but there is something called the license exception, which will allow you to engage in that same transaction that's already been determined to raise a high level of concern to the U.S. government by using the appropriate license exception based on the exact details of your transaction and making certain those details comply with the guidance under the appropriate license exception. If your transaction does, in fact, require an export license, usually there will be terms or conditions of approval for that transaction. So in that case, you must comply with any and all terms and conditions applied to that approved license. Now, the actual U.S. supplier does not always have to be the exporter of record. You may hire any of the shipping services or a freight forwarder to handle the paperwork and the determination of whether the export license is required for your transaction. That's not a problem. Transactions can be structured any number of ways under our regulations. And we here at BIS do not get involved to that level in determining how you must structure your transaction. We simply state whatever you and the other parties to the transaction can agree upon must be in compliance with our regulations, export administration regulations. So yes, you may hire a freight forwarder to determine your export licensing requirements and apply for that license if it's needed. But in hiring someone else to handle that detail for you, you are still responsible for maintaining compliance with all applicable U.S. export laws and regulations. Any and every party involved in the transaction is responsible for maintaining compliance with U.S. export law and regulation. So that was the standard export transaction. Now there's something called a routed export transaction. That simply means the actual purchaser, end user, or customer of the U.S. supplier is controlling, dictating, orchestrating the flow of the item they are purchasing here in the U.S. to themselves. Generally, they have hired an agent here in the U.S. to act on their behalf. That agent must have what's called a power of attorney or something in writing giving them authorization to act on behalf of another party in this transaction. Remember, export transactions are legal transactions, and there are legal responsibilities for those that participate. So in order for someone to act on your behalf, that must be put in writing. So again, the customer, the purchaser, the foreign principal party in interest is directing the U.S. supplier to use a particular freight forwarder or agent located physically here in the U.S. And because they are controlling the flow of the item to themselves, that transaction is considered a routed transaction. Basically, the customer is routing the transaction through an agent in the U.S. acting on their behalf. So that's the distinction. Now, that was export license. Who can apply for a re-export license? Re-export license, or a re-export transaction, rather, would start outside of the U.S. So the transaction from the U.S. supplier to their customer would be the export. Now, that customer is actually a distributor, and they plan to resell this item to additional customers around the world. When the distributor outside of the U.S. sells to another customer also outside of the U.S., that is a re-export transaction, as long as that other customer is outside of the country of the distributor. So hypothetically, U.S. supplier ships to a customer in Germany. The customer in Germany is a distributor and plans to resell to a customer in Greece and Italy. Both of those transactions from Germany to Greece and from Germany to Italy would be considered re-export transactions. Now, if the U.S. supplier at the time of the original shipment from the U.S. to the distributor in Germany is aware that the distributor is going to resell to customers in Germany, in Italy and Greece, the U.S. supplier can, it's not their responsibility, but they can, based on the nature of the relationship between the parties, they can apply for re-export authorization for the distributor. Ultimately, under our regulations, the responsibility falls on the actual distributor located outside of the U.S. And again, our regulations will allow you to use another party acting on your behalf if you're not quite comfortable with the process, with the regulations, and you'd rather have someone else handle that for you. Again, that request must be put in writing because this is also a legal transaction. And as you get into the SNAP-R system, this would be the screen that comes up for the re-exporter. This would be the information we would need here at BIS, Bureau of Industry and Security, in order to review the transaction and be fairly certain there are no concerns with either the customer, their location, and what they plan to do with the item. So either export transaction, standard or routed, or a re-export transaction. You may require support documentation for the export transaction. But how do you determine what support documentation you'll need for your license application? Well, first and foremost, you can review Part 748.9 of our Export Administration Regulations. That's where you'll see the guidance that we'll cover during this presentation and how it may pertain to your particular transaction. Basically, you'll need either an import certificate, an end-user statement, or the statement by ultimate consignee and purchaser in support of your export license application. And which one of those would apply would depend on these factors that we're about to discuss now. Basically, your destination, your dollar value, and the reason for control of the item in question. Because we state you will need these documents within our regulations, there usually is also a set of circumstances that would dictate you do not require these documents. So if you are shipping to a Western Hemisphere destination, Central or South American country, excluding weapons like the shotgun, which is covered under 0A984, or a shotgun shell, which is covered under 08986, and the sighting device or scope 08987. If you're exporting any of those items, you will need support documentation because that transaction will require an export license. However, if the ultimate consignee or purchaser is the government or a government agency of any of these countries outside of the People's Republic of China, then you won't need that support documentation. If the customer is the government of China or a government agency representing China, you will still need that support documentation. You also will not need your support documentation for transactions involving software or technology. So it has to be a tangible item, no software or technology. And also, you will not need the support documents for encrypted items. So, when is the import certificate required? Well, again, the reason for control of the item in question has to be national security, again, excluding the encrypted items under 5A002 and 5B002. The country also must be listed in Part 748.9. That is one of the handouts you should have. And these are the countries that are participating with the U.S. government in this International Import Certificate program. Basically, the import certificate is a way that government, as well as the U.S. government, is verifying exactly who is using this item, where they're located, and what they're going to do with it. Again, that's important because, remember, the item in question is controlled for national security reasons. The International Import Certificate is going to be provided by the government within that country, a government agency. So the Bureau of Industry and Security here, the Commerce Department, provides import certificates for items that are imported by U.S. entities. We also have in Part 748, Supplement Number 4, a listing of all of the government agencies around the world that also would supply that import certificate for their country. Now, the dollar value is $50,000 or more that would dictate when that transaction requires the import certificate. So if it's less than $50,000 to these destinations, in the vast majority of your transactions, if it's less than $50,000, you will not require this import certificate. We do make exceptions for certain items that are controlled for missile technology. But again, by and large, the vast majority will not need the license, need the support documentation if it's below $50,000. And always remember to include the number on that import certificate in Block 13 of the license application submitted via the SNAP-R system. Again, we'll go into more detail with that a little later with the next presentation. So that was the import certificate. Now, what about the end user statement? When is that required? Well, it is required for all items controlled to the People's Republic of China, not just controlled for national security reasons. The dollar value threshold is still the same, $50,000, again, in most cases. And with the People's Republic of China, the end-user statement, or MOFCOM, MOFCOM is the Ministry of Commerce within China. That's the agency, the government agency that would issue this end-user statement. And again, please remember to include the number from that end-user statement in Block 13 of the application. So that was the import certificate, the end-user statement. Now, But what about the statement by ultimate consignee and purchaser? When is that required? You are required to use this statement when an import certificate or end user statement is not required. So you look at Part 748 and you look at those countries that are listed there. If your country is not there, then you don't need the import certificate. And if your country is not China, then you would not need the MOFCOM or end user statement. Then you would need the BIS 711 or statement by ultimate consignee and purchaser. And those countries would be found in country group D2, D3, and D4. All of our country groups can be found in supplement number 1 to part 740. So you want to go to part 740, supplement number 1, which is near the back, and look at country group D as in David to make sure your country is not in country group D2, D3, or D4. If they are, then with the other criteria, item being controlled for national security, dollar value for the transaction, $50,000 or more, you will need the statement by ultimate consignee in support of your export license application that is submitted electronically via the SNAP-R system. And this is the screen that will come up as you are submitting your information. As you can see, you would simply check the appropriate document that you are submitting. You will not use all three. It would only be one or the other, but you would never submit all three for any transaction. So you've made it safely through the SNAP-R process. You've navigated your way, submitted your application. You've received confirmation that your application has been officially registered here at BIS, Bureau of Industry and Security. And now you want to know, well, what's going on with my application? What is the status of my license application? Within 30 to maybe 45 minutes of your initial submission, you'll get confirmation that your application has been accepted, and that confirmation will come in the form of what's called an application control number. So you will get a notification via the SNAP-R system that you have a message, and when you look closer or look more closely into that message, you'll see the application control number. That's important because prior to this moment, applications that were submitted to the Commerce Department were submitted using a reference number that you or your organization has created. The Commerce Department would have no way of verifying or checking that reference number because we didn't create it. We wouldn't know who that reference number applied to. But once your application is officially registered, then if there's a question, everyone is on the same page because the application control number will coincide with the reference number you use to submit this application. But from that point on, anytime there's a question, we would all use the application control number or Z number. So your application will be accepted. You'll get that confirmation. Once it's accepted, the next step is for the application to be reviewed. While the application is being reviewed, it's officially in what's called the pending status. It's pending a review and a decision by one of 4 government agencies. Usually it's the U.S. Department of Commerce, the U.S. Department of Defense, the U.S. Department of Energy, and the U.S. Department of State. And that would depend which one of those agencies would review your application would depend on the details of that particular situation. If the application is referred to any of those other 3 government agencies, the U.S. Department of Defense, U.S. Department of Energy, or the U.S. Department of State, by law and under our regulations, each of those agencies will have 30 calendar days to review your information and respond with their official position. And we send the application to all agencies at the same time, so it may be sent from the Commerce Department to the Department of Defense and the Department of State, or just the Department of Energy. But when we submit the application for referral to these other agencies, we send it to each agency at the same time, and that's when the 30 days would start. The clock on the 30 days would start clicking. And usually the agencies do not take the full 30 days. Again, that's 30 calendar days, not 30 working days. So if there's a question about, well, how long will this application take to be approved, the Commerce Department does not have a definitive time frame. We don't say this application will be approved in 20 days, and 14 days, and 22 days, because we don't know if it's referred outside of the Commerce Department for review how long that other agency will take. Again, by law, they have the full 30-day period. Usually, they don't take the full 30 days. We don't know. So we have to incorporate that 30-day time period into our processing time. So the response the Commerce Department provides to the question, well, what's the general time frame for the review of an application, would be 4 to 6 weeks. The initial 2 weeks would be done solely here at the Commerce Department. If it does not have to be referred outside of the Commerce Department for any input, then you're looking at a possible 2-week turnaround time on that application. If it does have to be referred outside of the Commerce Department, again, we have to incorporate that 30-day period. That's where the other 4 weeks come into the picture. So 4 to 6 weeks is the review time. That's general because each application is reviewed on a case-by-case basis. Depending on the decision by the other agencies, if everyone is in agreement, then your application will be recommended for approval by the licensing officer or individual here at BIS that was assigned your application. That licensing officer's supervisor or division director will just review the process to make sure all applicable U.S. export laws and regulations were followed, and that review is what's called the countersigning procedure or countersigning step in the process to review your license. So basically, after it's recommended for approval by all parties and the supervisor reviews your application, at that point has become an approved license. Your Z number or application control number will be replaced by a license number, which will start with the letter D as in David, followed by 6 digits. So that's an approved application. Now it's an approved license. What if everyone was in agreement not to approve your transaction? Then your transaction, your application will be denied, and you'll get the reason for the denial from the Commerce Department in writing. There also are situations where there's not enough information provided with the application, and the Commerce Department cannot render a final decision until we get certain questions answered. In that case, the licensing officer will notify the applicant, the point of contact on the application that submitted the application to the Commerce Department. The licensing officer will notify that individual of a particular question or series of questions that have come up during the review of this application. If those questions are not answered within, I believe it's 14 days, 14 to 18 days, then the licensing officer at that time will return your application without action pending the answers to the questions that were raised. When an application is returned without action, it's returned without prejudice. So you can resubmit that application, but the original submission, a final decision could not be rendered because there were questions that came up that needed to be addressed before the U.S. government could make that final determination. So again, your application will be accepted first. Once it's accepted, you'll be You'll receive a Z number, and then your application will be pending. And once everyone has reviewed the information and responded with their position, your application will either be approved or denied, or if there's not enough information, it's going to be returned without action. So, in summation, support documents. Only a person in the United States may apply for an export license. So remember, you have to physically be in the U.S. in order to apply for an export license. The support documentation requirements that were just covered are all found in Part 748 of the Export Administration Regulations, beginning with Part 748.9, which identifies the countries that are accepted from the support documentation requirements.
Thank you, Doug. And now we'll open up the lines for voice questions. If you have a voice question and like to ask a question, please press *1 on your telephone. Thank you, Doug. Once again, to ask a voice question, please press *1. Operator?
Ma'am, at this time I'm showing no questions.
Okay, I'll go on with one of our written questions from Robert Wooler. Excuse me for the mispronunciation of the last name. The question is, do I need the original of the import permit, or can a certified copy be acceptable?
Prior to the actual shipment, you will need the original document in your possession, but for the Commerce Department to review your application and render a decision, all we would need is the number from that document, so a fax would be fine. We don't need the original to review and process your application, but yes, you will need the original in your possession prior to the actual shipment.
Okay, great. Thank you. Next question here I have from Rebecca League. Please explain the difference between the ultimate consignee and the purchaser. For example, if we sell to a distributor or reseller, are they both the ultimate consignee and the purchaser, or is the distributor reseller the purchaser and is their customer the ultimate consignee?
Well, that's exactly why here at BIS we have to review the transactions on a case-by-case basis. Again, transactions can be structured any number of ways. Generally, the purchaser and the ultimate consignee would be one and the same for most transactions. That's a situation where the U.S. supplier ships directly to the purchaser or the foreign entity that has contacted them requesting the item, and that entity is also going to be the final end user or ultimate consignee. Now, if you're shipping to a distributor, under our regulations, BIS does not require that you know all of the customers or all of the potential customers of your customer. So in that situation, the distributor would be your purchaser and ultimate consignee. But if they are going to resell, again, that would become possibly a re-export transaction, and they would be responsible for maintaining compliance with these U.S. export or re-export laws and regulations.
Okay, great. Thank you, Doug. One last time, if anyone has a voice question, please press *1 on your telephone. Operator, are there any voice questions?
At this time, ma'am, I'm showing no questions.
Okay, then we'll go to our last two written questions. One is from Cami Tang. The question is, in a routed export transaction where the FPPI has selected and hired the U.S. agent, if the U.S. PPI has obtained a license for the shipment and supplied this information to the U.S. agent, and the FPPI's agent incorrectly files the AS filing, for example, state's NLR or the AES filing, what are the ramifications for the U.S. PPI? Will we be penalized by the Bureau of Industry and Security?
No, actually, with a routed transaction, the bulk of that responsibility would fall on the agent in the U.S. acting on behalf of the foreign principal party of interest. But again, remember, all parties to a transaction are responsible for maintaining compliance with these U.S. export laws and regulations. We understand that you are limited in the control you would have over the item in this situation. So as an investigation unfolds, we'll determine who is more responsible for whatever infraction that possibly could have occurred and act accordingly. So no, you would not be unduly penalized for situations beyond your control. Again, you're involved in a routed transaction, so your customer is dictating the flow of the item to themselves. So we understand that situation, and we will review, investigate, and act accordingly at that moment.
Great, thank you. And our last question is from Dan Sherwin. What language would you suggest be submitted with the SNAP-R to allow a license application to progress while MOF-COM end-user statement is still pending? And I guess the question is what language, maybe Dan, if you'd like to ask the question online, let's review this one more time. Yeah, Dan, if you would like to clarify that question, please press *1, and that way we can help answer your question. And then another question I have for you, Doug, is if they have a question, what is the best way? Can they ask you, or should they call the Bureau of Industry and Security main line?
Either is fine. Either they can call the 202-482-4811 number, and that's where they'll reach all of the export counselors here at BIS, or they can use our email notification and submit the question via email, or they can contact me directly. Either of those three would be fine.
Okay, so Dan, if you can call in, press *1, and we can clarify your question for you. If not, call Doug at that number at 202-482-4811, and then we can help answer your last question.
Ma'am, Dan's line is open.
Okay.
I'm online now. Can you hear me?
Yeah, we can hear you. Thanks for calling.
Sure. Doug, I just wanted to ask you, for a license application going to China that requires a MOFCOM, is it possible to parallel path those? Because I'm told it takes about 60 days before the MOFCOM end-user statement will be issued.
Yes. Well, again, that's a case-by-case process, so it does vary. But while your application is being processed, you can also be obtaining your MOFCOM. So the bottom line is you cannot export, you cannot ship before you have that document, but your application will be reviewed in the meantime. So you can submit your application as you are trying to obtain the MOFCOM from your Chinese customer or end user.
Is there any documentation that I should attach along with checking the end-user statement box?
No. No. When the licensing officer or the individual here at BIS is reviewing your application, if they have any questions about your transaction, especially the support documentation, they will notify you through the SNAP-R system. And once you get that notice, then you'll know exactly what the issue or what the question is. And if it's pertaining to your MOFCOM, you can notify the licensing officer at that time that you've already submitted your request to your customer. Your customer has responded. They are awaiting the document from the government agency in China. So your application is still being reviewed at this time. So it won't be delayed because you don't have your MOFCOM. But again, you cannot begin the shipping of your item until you have that document.
Okay, thank you.
You're welcome.
Okay, well then, if there are no more questions, that concludes our presentation and webinar for today. Remember, for those of you who might have questions after this webinar, please note that telephone number 202-482-4811 as a number to call for export counseling. Also, I'd like to recommend that you check out the Bureau of Industry Security's website at www.bis.doc.gov for information on this topic and other important information from that agency. Also, please check www.export.gov for more information on this webinar series that we're doing with the Bureau of Industry and Security. This is a nine webinar series. They have condensed it from a 2 all-day conference for 9 webinars for an hour, so it's a great money saver for everyone to take advantage of this information. If you want to register for the next classes or the courses or webinars, we have one this afternoon in SNAP-R. We have 2 tomorrow, one on export clearance and records in the morning, and then we also have one in the afternoon tomorrow on the export management compliance at 2 o'clock, which I heard is a very important webinar. So if you have to register or need to register, we would recommend that you do the export management compliance one in the afternoon tomorrow. I'd like to thank all of our participants for your interest and for logging in today for today's webinar. And of course, I'd like to thank my main speaker here, Doug Bell, for his expertise. And everybody, thank you for joining us, and please check your email boxes for more information on upcoming webinars and events. Goodbye.